Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.
People v. Rosemary Hernandez, decided October 23, 2025. Rivera, J. The two issues on appeal concern defendant Rosemary Hernandez's sentence imposed under the Domestic Violence Survivors Justice Act, DVSJA, an alternative sentencing scheme, following her guilty plea to second-degree murder. Defendants claim that her sentence is illegal because the court imposed a term of 5 years post-release supervision, PRS, is meritless. The penal law mandates that a court impose a 5-year PRS term whenever a defendant is convicted of second-degree murder, a Class A.I. felony, and sentenced under the DVSJA to a determinate term of incarceration, as defendant was here. Defendant's separate assertion that her appeal waiver is invalid is also meritless, and accordingly, the Appellate Division did not err when it held that the waiver barred consideration of her excessive sentence claim. We therefore affirm. 1. Defendant was charged with murder in the second degree and other offenses. Based on the charges, she faced a minimum indeterminate sentence of 15 years to life incarceration if convicted at trial. See Penal Law 70.002A3AI. However, after negotiations, the prosecution recommended that defendant plead guilty to second-degree murder in exchange for sentencing under the DVSJA to 10 years incarceration and 5 years PRS, and a waiver of her right to appeal. Supreme Court concluded based on defendant's submissions, as well as the prosecution's and defense counsel's statements on the record, that it would have found defendant entitled to such a sentence under the DVSJA had it held an evidentiary hearing, and it therefore agreed to impose the recommended sentence. During the plea colloquy, the court explained that as a condition of her guilty plea, defendant was being asked to waive her separate and independent right to appeal. Defendant responded that she understood, and after conferring with counsel, she also executed a written appeal waiver. She then admitted guilt to second-degree murder. On appeal to the Appellate Division, defendant argued that the 5-year PRS term is illegal, because the penal law does not permit a court to impose PRS on a defendant convicted of a Class A felony and sentenced under the DVSJA. Defendant further argued that her sentence is unduly harsh and severe, and that the Appellate Division could consider this claim because her appeal waiver is invalid. The Appellate Division affirmed the judgment, concluding, as an initial matter, that defendant's appeal waiver is valid. The court next held that, although the appeal waiver did not preclude defendant's challenge to the legality of her sentence, the relevant DVSJA and penal law provisions did not bar imposition of the 5-year PRS term. The court also held that defendant's valid appeal waiver foreclosed review of her excessive sentence claim, but, in any event, there was no basis to reduce her sentence. A judge of this court granted defendant leave to appeal. Defendant now repeats her challenges to the legality of her sentence and the validity of her appeal waiver. We agree with the Appellate Division that those claims are without merit, and we therefore affirm. A. Legality of defendant's sentence. Defendant does not challenge the carceral component of her sentence. Instead, she asserts that the court had no statutory authority to impose 5 years PRS on a defendant convicted of a Class A felony and sentenced under the DVSJA. We may review defendant's claim that her sentence is illegal even though, as we explain, her appeal waiver is valid. See People v. Seberg. A defendant may not waive the right to challenge the legality of a sentence. However, defendant misinterprets the statutory scheme, and her claim boils down to a policy argument best suited for the legislature, not the judiciary. When we interpret a statute, our primary consideration is to ascertain and give effect to the intention of the legislature. People v. Galindo, quoting Riley v. County of Broome. As the clearest indicator of legislative intent is the statutory text, the starting point in any case of interpretation must be the language itself, giving effect to the plain meaning thereof. Moreover, it is a well-settled principle of statutory construction that a statute or ordinance must be construed as a whole and that its various sections must be considered together and with reference to each other. People v. Mobil Oil Corporation. The legislature enacted the DVSJA in recognition of the national epidemic of domestic violence and the failure of prior law to allow judges discretion to fully consider the impact of domestic violence in making sentencing determinations. People v. Brenda W.W. The DVSJA permits courts to sentence defendants to an alternative, less severe sentence if the defendant was a victim of domestic violence and convicted of certain eligible offenses. Penal Law 60.12, as amended by the DVSJA, provides in relevant part that notwithstanding any other provision of law, where a court is imposing sentence upon a person pursuant to PL 70.00 and is authorized or required to impose a sentence of imprisonment, the court, upon a determination that the person qualifies for DVSJA sentencing, may instead impose a sentence in accordance with this section. Penal Law 60.12(1). In turn, Penal Law 60.123 states that where a court would otherwise be required to impose a sentence for a Class A felony offense pursuant to Penal Law 70.00, the court may fix a determinate term of imprisonment of at least 5 years and not to exceed 15 years. By its plain text, Penal Law 60.12 does not reference PRS or expressly prohibit courts from imposing a period of PRS in addition to a term of incarceration. It only reduces the period of incarceration a court may impose on defendants eligible for DVSJA sentencing, based on class of felony. Here, Penal Law 60.123 permitted the court to sentence defendant to a determinate term of incarceration of between 5 and 15 years based on her conviction of a Class A felony. A separate section, Penal Law 70.45, governs PRS. That section requires that when a court imposes a determinate sentence it shall in each case state not only the term of imprisonment, but also an additional period of post-release supervision as determined pursuant to this article. Penal Law 70.45(1). Under Penal Law 70.45(2), the period of post-release supervision for a determinate sentence, other than a determinate sentence imposed for a felony sex offense as defined in Penal Law 70.80(1)(a), shall be 5 years, unless the offense of conviction falls within one of 6 enumerated categories based on its severity, in which case the court must impose a shorter PRS term. The 6 enumerated categories, by express reference, include defendants convicted of Class B, C, D, and E felonies and sentenced under PL 60.12, as amended by the DVSJA. For example, a defendant convicted of a Class B violent felony and sentenced under the DVSJA to a determinate term of incarceration must receive between 2.5 and 5 years PRS, see Penal Law 70.45(2)(f). Since none of the 6 categories encompass Class A felonies, the 5-year default PRS term applies to defendants' conviction of second-degree murder. The court therefore imposed a lawful sentence under the applicable statutes. Contrary to defendant's assertion, the notwithstanding prefatory clause in Penal Law 60.12(1) does not change the analysis. We reject defendant's argument that it precludes a court from imposing PRS on a defendant sentenced under the DVSJA to a Class A felony because Penal Law 60.123 does not expressly authorize it to do so. The notwithstanding clause merely ensures that Penal Law 60.12's sentencing rules preempt conflicting provisions in any other statute. See People v. Mitchell, explaining that the phrase notwithstanding any provision of law to the contrary is the verbal formulation frequently employed for legislative directives intended to preempt any other potentially conflicting statute, wherever found in the state's law. But Penal Law 60.12 and Penal Law 70.45 do not conflict. Penal Law 60.12 controls the length of a DVSJA eligible defendant's term of incarceration, while Penal Law 70.45 directs that a court order an additional period of post-release supervision on any determinate sentence of incarceration. Penal Law 60.12 therefore does not preclude a court from imposing PRS. Instead, these sections work in tandem to achieve the legislative design of setting both a period of incarceration and supervision upon release, each directly related to the class of crime for which a defendant is convicted. The legislative history of the DVSJA supports our straightforward reading of the penal law, and our conclusion that the legislature only intended to give judges discretion to reduce the periods of incarceration for certain defendants who are domestic violence survivors, not to wholly eliminate PRS in such cases. Defendants' argument that the legislature intended to front-load punishment of DVSJA-eligible defendants convicted of serious offenses like second-degree murder by imposing longer terms of incarceration but shorter terms of PRS, as compared to defendants convicted of less serious offenses, is not supported by the statutory framework. Indeed, defendants generally face higher maximum terms of incarceration, see Penal Law 60.12, and wider ranges of PRS, see Penal Law 70.45, 2, the more serious their offense of conviction. For example, a defendant sentenced under Penal Law 60.12 on a Class E violent felony faces up to 1.5 years incarceration in between 1.5 and 3 years PRS, see Penal Law 60.12, 2, D, 70.45, 2, E. By contrast, a defendant sentenced on a Class C violent felony faces up to 3.5 years incarceration in between 2.5 and 5 years PRS, Penal Law 60.12, 2, B, 70.45, 2, F. Defendant's argument entirely relies on the fact that Penal Law 70.45 does not expressly state a PRS term for defendants sentenced under the DVSJA on a Class A, I, felony, and that such defendants face higher maximum sentences than defendants sentenced under the DVSJA to less severe felonies. However, as explained above, since the default rule of 5 years PRS applies to defendants sentenced under the DVSJA to Class A felonies, there was no need for Penal Law 70.45 to expressly reference them. Consequently, Penal Law 60.12 and 70.45 do not reflect a legislative intent to front-load punishment through lengthier terms of incarceration and shorter terms of PRS for defendants sentenced under the DVSJA to the most severe crimes. Finally, defendants' argument that PRS undermines successful reentry for defendants sentenced under the DVSJA is a policy consideration for the legislature, see People v. Jones. These policy determinations are beyond our authority and instead best left for the legislature. People v. Francis. The constitutional principle of separation of powers requires that the legislature make the critical policy decisions. In sum, defendants' proposed reading of Penal Law 60.12 ignores well-settled rules of statutory interpretation and rests on speculative claims of legislative intent belied by the statutory framework. Thus, defendant's sentence is not illegal. B. Validity of defendant's appeal waiver. Defendant separately argues that her appeal waiver is invalid because the court misrepresented which claims would survive it and, consequently, it did not preclude her claim to the appellate division that her 10-year term of incarceration is unduly harsh and severe. An appeal waiver is valid when the record demonstrates that it was made knowingly, intelligently, and voluntarily. People v. Lopez. The court does not have to engage in any particular litany to ensure that an appeal waiver is knowing, intelligent, and voluntary, but it must ensure that the terms and conditions of an appeal waiver, and a defendant's understanding of them, are apparent on the face of the record. People v. Callahan. Moreover, a court cannot mischaracterize the rights encompassed by an appeal waiver. People v. Bissonnette. Here, the court specifically advised defendant that certain issues would survive the waiver, and counsel confirmed that they had reviewed those issues with defendant. The written waiver further clarified that, as explained in defendant's conversation with the court and counsel, defendant was waiving any claim that her sentence is excessive. Under these circumstances, the appellate division properly concluded that defendant knowingly, intelligently and voluntarily waived her excessive sentence claim. Accordingly, the order of the appellate division should be affirmed. Order affirmed. Opinion by Judge Rivera. Chief Judge Wilson and Judges Garcia, Singas, Canataro, Troutman and Halligan concur. Decided October 23, 202.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.org niptlaw.niptlaw.com/law to read the full decision.